Suit upon quantum meruit, where a party to the contract performs the contract partially and the other party breaches the contract, a suit can be filed to claim proportionate remuneration. It is called suit upon the quantum meruit. The term quantum meruit means as much as is earned in proportion to the work done. When a person has done some work under a contract and the other party cancels the contract, or an event happens which makes the performance of the contract impossible, such party can claim remuneration for the work already done. The aggrieved party may sue the quantum meruit in following cases. Where the work has been done and accepted, the contract becomes void before completion. Where a person does some act without an agreement about the remuneration and the party enjoys the benefit. Where a person does some act with the intention of receiving payment, another party enjoys the benefit. When the contract is divisible and the party has enjoyed benefit of the partial performance. When one party prevents the other from completion of the contract. When an indivisible work is performed badly. Suit for specific performance. It is a decree issued by court to require the guilty party to complete his obligation according to the terms of the contract. It is a discretionary remedy. It granted it is granted when the aggrieved party satisfied the code that the remedy of damages is inadequate. The aggrieved party can sue for the specific performance in the following cases: when monetary compensation is not an adequate remedy, when it is difficult to calculate the actual damages, when compensation in monetary cannot be obtained. Specific performance is not granted in the following cases: when damages are an adequate remedy, when the court cannot supervise the performance of a contract, for example, construction contract, when the contract involves a personal skill, taste, and qualification, when one party to the contract is a minor. Suit for injunctions. It is the order of the court by which a party is prevented from breaching the contractual obligations. It means to demand a court stay order. Injunction means an order of a court which prohibits a person from doing a particular act. Where a party to a contract does something which he promised not to do, the court may issue an order prohibiting him from doing so. Well, this was all about the 10th phase. We talked about the contracts, and now we talk about indemnity and guarantee in 11th stage of the series of tutorial and voiceover. So we talk about the contract of indemnity, we talk about the contract of guarantee. Indemnity and guarantee. The term indemnity means to compensate the party who suffers a loss. A contract of indemnity is an obligation by one person to provide compensation to the other party for a particular loss suffered by him.